Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Well, good morning, everybody, and welcome to the September 29th, 2020 meeting of the Hillsborough County Land Use Hearing Officer. My name is James Scarola, and I'm going to be the hearing officer for the morning. What we'll do to get things kicked off this morning is first you'll hear me have a brief discussion with staff about any changes, if there are any, to our agenda. I'll do a brief review of procedures following that, and then we'll move right into our cases. We have a relatively small agenda this morning. So with that, I'll introduce Mr. Tom Hisney, Development Services Department. Good morning, Tom.
Good morning, Mr. Scarola. To my left, we have Carmen Mason. She's of Development Services Hearing Support Staff. Also assisting us today virtually is Cameron Clark of the County Attorney's Office. We have one change to the agenda, and that is item G1, Variance Application 20-0372. The applicant is Martinez Yane and Unica Maria. This application is out of order to be heard. It is being continued to the October 19th, 2020 Land Use Hearing Officer meeting. Excuse me. Also like to read in then the published withdrawals and continuances. Excuse me. Item A1, Special Use General Application 19-1174. Applicant Denise Donaldson. This application is out of order to be heard and is being continued to the October 19th, 2020 Land Use Hearing Officer meeting. Item A2, Variance Application 20-0244. Applicant is Russell Capel. This application is out of order to be heard and is being continued to the November 16th, 2020 Land Use Hearing Officer meeting. Item A3, Variance Application 20-0317. The applicant is John Schuman. This case is out of order to be heard and is being continued to the November 16th, 2020 Land Use Hearing Officer meeting. Item A4, Variance Application 20-0398. The applicant is Eloy Martinez. This case is out of order to be heard and is being continued to the October 19th, 2020 Land Use Hearing Officer meeting. Item A4, I'm sorry, excuse me, item A5, Variance Application 20-0869. The applicant is Gentai Tariha. This application is out of order to be heard and is being continued to the October 19th, 2020 Land Use Hearing Officer meeting. Item A6, Variance Application 20-0899. The applicant is TSB Companies Incorporated. This application is out of order to be heard and is being continued to the November 16th, 2020 Land Use Hearing Officer meeting. And finally, item A7, Variance Application 20-0992. April and Jason Foreman. This applicant has requested the case to be continued to the December 14th, 2020 Land Use Hearing Officer meeting. That concludes the continuances and withdrawals.
Okay, thank you for that, Tom. So ladies and gentlemen, with respect to our hearing today, the hearing is generally going to be informal. Questioning will be confined as closely as possible to the scope of direct testimony, which simply means you'll be speaking directly with me when you come up here. As the hearing officer, I'll call and question witnesses as necessary and appropriate, and I'll be deciding all questions on procedure. Irrelevant, immaterial, and unduly repetitious evidence will be excluded. Any part of your evidence may be received in written form. All of your testimony today is going to be under oath. Hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but it won't be sufficient in itself to support a finding unless it would be admissible over objections in a civil action. Having said that, what will happen here for each case today is that after a brief introduction, the Development Services staff will present a short summary of their staff report on the petition. They'll have about 5 minutes to do that. Then I'll ask for the applicant and any of their witnesses, and you'll have the opportunity to come forward for a total of up to 15 minutes and present any supporting testimony or evidence. At that point, I'll ask for any proponents. Proponents are not the applicant again. Instead, there may be other parties in supporting the petition, and there'll be an equal time of up to 15 minutes total set aside for any proponents. At that point, I'll ask for any opposition if there's opposition in the audience. Similarly, a total time period of 15 minutes will be set up. Hopefully, if there are groups, there's a primary speaker appointed. If not, I'm just going to divide up the time, but 15 minutes for opposition. I'll then turn to staff to see if there's any changes based on the testimony provided. And lastly, the applicant will have an opportunity for a final rebuttal, and that's for a period of 5 minutes. A couple of quick tips for you. When you come forward, there's a microphone up at the podium. Take the microphone, pull it down close to your mouth first, and always start with your name and address. Name and address. If for whatever reasons you sit down and we agree that there's a reason for you to come back up forward again, no need to repeat the address, but definitely a need to always repeat your name when you come back up, and that's because there's a record being established. When you're all done testifying, to my right, Allison has a sign-in sheet. And if you would just step over from the podium to the sign-in sheet. If there's copies of evidence, you can present it there, and you can also sign in to show that, that you testified today or presented evidence. So with that, I'm going to now ask, hopefully virtually online, we have our assistant county attorney that can provide for you an explanation of your appeal right with regards to decisions made as a result of the resulting from today's hearing. Mr. Clark, are you out there?
I am. Thank you, Mr. Scrolla. Good morning. My name is Cameron Clark. I'm an assistant county attorney. This land use hearing officer public hearing is for variance requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record that is made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, by county staff, and by any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. First is the applicant. Second is anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the Appeals Board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the Appeals Board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the Appeals Board that is outside the record made at today's hearing could jeopardize the legality of the Appeals Board decision, and the presenter of that evidence could hurt their own cause. The safest course of action then is for you to write down any comments you make today and to repeat those comments to the Appeals Board. Thank you.
Thank you, Mr. Clark. And I should add, ladies and gentlemen, that at the end of our agenda, we have an appeal request, and the instructions changed a little bit for that. I'll go over it once we get to that particular point in time. But for anybody that's going to present today or give any testimony and evidence, I'd like you to rise now with me and raise your right hand, please. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. All right. With that, Tom, I think we're ready for our first petition.
All right, we have no vested rights cases today, no fee waiver requests, no reconsideration requests, or no site development variance requests, which then takes us to section F of the agenda, sign variances. We have one sign variance application. It's item F1. Application number is 20-0870. The applicant is Stacy Friello. They're requesting a sign variance, and staff findings will be presented by Kim Keene.
Good morning. Kim King, Development Services. The applicant is requesting a variance for an additional building sign on the east elevation of the building. This request is for Broken Yoke Cafe located at 10442 North Dale Mabry Highway. Per section 7.03.00.A2 of the Land Development Code allows 69 square feet of sign area for this tenant space with building frontage of 55 feet. The applicant is requesting a variance for 25 square feet of additional signage on the east elevation of the building, and the existing signage on the building is 44 square feet. And I'm available if you have any questions.
Nobody now, Kim, but thank you for that testimony. Yes, ma'am, thank you. And good morning to you.
Good morning. My name is Stacy Friello. Company name is Sign Source. Address is 1780 Main Street. That is Suite A and B in Dunedin, Florida, 34698.
Thank you.
We don't have the display line. Oh, we do right
Yeah,
here?
you do.
Great. And it just. So right now, what I'm going to do is propose, we were the original sign company that permitted and fabricated and installed the signage for the Broken Yoke. So what I'm doing now is showing you the engineering that was submitted, showing you the linear frontage, what was proposed, what was granted, and what was installed. So that was our proposal into Hillsborough County. This is our final drawing, a photo of the sign. Excuse me, showing that the sign already proposed, permitted, and so on. Now, this is what we're going for a variance for. We're proposing a variance. Let me move this up here.
Just a hair higher. Just a
Little bit higher. There
Yep.
we go.
Right there.
I'm getting good at it.
Uh-huh.
So basically what we're having is in this restaurant, they have 23 parking spaces in the front of their building that face the east elevation and 2 handicap spaces. They have also now grown to be entitled to an additional 38 parking spaces and 1 handicap space behind the building. The problem is that there's no way to tell restaurant comers and people that want to have breakfast that we do have additional parking in the rear. So they're trying to do some sort of sign, something just to really let everyone know, because number one, it's causing issues within the shopping center. There's a lot of limited parking. And with those additional 38 parking spaces in the back, it would really help clear up a lot of congestion that we have going on there. And obviously, due to COVID, we're having a lot of issues with people being afraid just to enter a restaurant, seeing this conglomerate of parking and being fearful and then moving on or not dining at all. So basically, it's just a small sign. It's 35 inches by 102 inches. We came up with that square footage just to make it seen well enough when you're turning in off of Dale Mabry Highway. You can say, oh, we've got some parking in the rear. What I did do was I went ahead and I tried to do some photographs on my own, but sometimes you just can't get that good photograph. So I did some Google Earth images just to show you what we're looking at. So okay, as you can see where we
Oh,
are.
you got to stand that mic. You can pull it over towards you if you need to hang out.
Yeah, I'm gonna just maneuver myself back and forth. Obviously, this is our parcel where we're at. So you can see where you have Dale Mabry Highway, you see those parking spaces there. And then if you look onto the west side, you can see those parking spaces as well. Now you do have some trees covering up the area. So what I did is I went ahead and got a better image going into that parking lot just to basically back up that there are 38 spots, so on and so forth. And to kind of give it the understanding of that it is a complete drive, it is completely concrete, you know, actual parking spaces, it's not a dirt road, no one can get hurt, so on and so forth. And there is backyard lighting there as well. So this is our, well, I am not good at this. Thank you. We're getting creative here
Right.
today.
That was good.
Okay, so this
Up-
is
Up
basically,
just a hair. Yeah,
there we go.
that's perfect.
So this is basically what we're looking at. So you can see right in front of that tree to the left, that is the driveway into that rear parking lot area. So again, the reason being is why are we asking for an LED illuminated box sign? Well, it gets dark in the morning and this breakfast company opens at 6 o'clock in the morning for breakfast. So we want to have that sign illuminated for those newcomers in the morning. Not only that, but placing just a 12 by 18 parking sign per se right off of Dale Mabry, what are the chances of people really seeing that sign? So that's why we're asking for an illuminated box sign to basically not only help the Broken Yoke restaurant, but to help all those other small shops. Maybe everyone can share a little bit more, get everyone in there, and then everyone can enjoy their breakfast, lunch, dinners, and have no issues.
I got to tell you, my one question here is why the roughly 3 by 9 size? I mean, that size is pretty dominant next to the actual sign that's above it.
Well, we did that. So what we did is I started off really small. So I started off with something, and then I did, you take your letter height. So basically, when you have your heights, when you have a 12-inch letter, what they do is they'll say, what can the eye see from Dale Mabry? So we proposed originally, because again, we're thinking of cost, and I'm thinking as well, the smaller the sign that I'm asking for, the better the chance that I'm going to win this variance, because people would, basically say, okay, it's not obtrusive, it's not this, it's not that. But then I'm going, if I'm only proposing 6-inch tall letters, what are the chances that people really are going to see this? And then what are the chances if I'm driving down Dale Mabry and I'm looking and now I'm squinting to try to see what does that sign say? Because I see an arrow, but I'm not really understanding what's going on here. So what we did is we did a mathematical equation going at 12 inches tall in letter height. I was technically able to see it with glasses on from Dale Mabry. So that's why we made that sign proposal of that size. And then we tried to keep it.
So in short, you did do analytics on the need for those letters to be that size for you to see.
That's how, that's how we started it off at 6 inches and we started to grow, but I didn't want to have to take you through my math equation from 6, 7, 8, 9, 10, 11, 12. And then that's basically how we ran it. And again, I'm probably the best one to judge because I have to wear glasses. And I was the one that was running that survey personally going, okay, this is what I'm comfortable with. Because of course we don't want to sell a sign to a customer that's just wasted space. It's just not necessary.
Anything else?
Basically, no, that's everything. Any questions that you guys may have for me?
I have nothing else. Thank you.
Okay, thank you so much.
All right, anybody here today in support of this request? Seeing none, is there any opposition to this request? No. All right, with that, we're going to close variance 20-0870. Tom?
All right, that concludes section F of the agenda. We'll now move to section G, general variance request. Item G1, variance 20-0372. That was actually continued at the beginning of this hearing to the October 19th land use hearing officer meeting. That'll take us then to item G2, variance application 20-0988. The applicant is Amber 2, requesting a variance to accessory structure requirements. Staff findings will be presented by Steve Beachy.
Mr. Beachy, are you there?
There we go. Sorry, let me start again. Good morning, Steve Beachy, Development Services. The applicant is requesting 2 variances for a proposed accessory structure on a property zoned ASC1. Per Land Development Code 61104B, accessory structure shall not exceed 15 feet in height unless they meet the primary building setbacks. The applicant is proposing a 2-story building approximately 28 feet in height. Per Land Development Code 60101, a minimum setback of 50 feet is required in the ASC1 district. The applicant requests a 25-foot reduction to the required rear yard setback to allow a rear yard setback of 25 feet from the north property line. The second request is for a variance of rear yard coverage. Per Land Development Code 61104C3, an accessory structure may occupy no more than 20% of the required rear yard. The applicant requests a 13% increase in the permitted coverage of the required rear yard to allow a 33% coverage. As far as findings, this lot does not meet minimum lot size and lot width for a parcel zoned ASC1. The applicant has obtained a non-conforming lot determination. That concludes my remarks.
Thank you, Mr. Beachy. And the applicant, please. Variance 20-988.
Good morning. My name is Amber Tu. My address is 2002 Holloway Road, Plant City, Florida, 33567. I'm the representing agent for Mr. and Mrs. Higgins, the property owners. The accessory structure that Mr. Higgins is looking to have built is a garage. The proposed garage will be 28 feet in height, and it will be a 2-story. The second floor will be for storage. He does currently have an existing slab, concrete slab, so he wants to utilize the slab that is there. So that's why we are seeking the variance for the setback and the occupancy of the rear yard as well. Thank you.
And Ms. Tu, has there been any conversations with the neighbor to the, would be to the north?
I'm sorry.
Are you with me?
I am. I didn't hear you. I'm sorry.
Can you hear me now?
I can. Yes, sir.
Were there any conversations with the neighbor to the north behind the rear yard?
Not to my knowledge.
Okay. What was that slab previously used for?
I believe it was poured for this structure.
And what was the time frame of that?
I'm not sure.
Could you say again?
Oh, I'm sorry. I'm sure. I'm not sure what the time frame was.
So I'm looking at your responses to the variance criteria, and I'm not sure I understand why the alleged hardship is unique and singular to the property. Can you maybe elaborate on that? Why is this hardship unique to this property?
Well, Mr. Higgins, he is wanting to, he works on cars in spare time, and that's what he would like to have, a garage that would suffice for that. And he would like to have it on his property. So that's why we think it's singular to this property.
Were there any similar structures anywhere in the neighborhood?
Not to my knowledge.
Okay. All right. Anything else you need to add to the application?
No, sir.
Thanks for that. Is there anybody here today in support of this request? Okay, seeing none, is there any opposition to the request? Nope. Mr. Beachy, do you need to add anything?
I would say the only thing I would add is that there was a call from the party that lived behind the to the north, and they just asked me what the variance request was about, and they didn't really register any strong opposition or support.
Thanks for that. It's good information. And Ms. Tu, anything else to add before I close it?
No, sir.
All right, with that, we'll close variance 20-0988.
Okay, well, that concludes the variances, and then moves us to the final case today, which is there are no special uses, takes us into section I of the agenda, which is the appeals. I1 is appeal 20-1151. The applicant is Unique Deals LLC. The applicant is appealing the administrator's decision and non-conforming use review NCU 19-0909 concerning property located at 11345 US Highway South and identified as tax folio numbers 51130.0200 and 51132.0000. The NCU decision was dated July 22nd, 2020. The subject appeal was submitted on August 20, 2020, and therefore was timely filed.
Okay, thanks for that, Tom. All right, a couple of pre-hearing matters. Let's first establish the parties. So is the appellant here? Good morning.
Good morning, Cami Corbett, 101 East Kennedy Boulevard, Suite 3700, here for the applicant, Unique Deals.
Okay. And Hillsborough County, Tom is being represented by who?
By me.
Okay, by Tom Hisney. Are there any interveners in the audience? Okay, seeing none. This is now going to be limited to the appellant and in Hillsborough County. Let's see. I think before, well, first we're going to, the procedure is going to be, and this is unless I receive any comments, is going to be 15 minutes by the appellant, 15 minutes by Hillsborough County, and then a 5-minute rebuttal from the appellant. But let me state right off the bat that I've read this application for appeal. And the application itself had some inconsistencies that I don't quite understand, and maybe you can add to it. I have the application form submitted to Hillsborough County, and it lists folio numbers that are different than everything that I see in the write-ups. And similarly, the addresses are different, or at least an address is different. Are you already familiar with that issue?
Excuse me, I'm going to ask Jamie Mayer from my office to approach.
Morning.
So I prepared everything,
Go ahead
but,
and say your name and address.
Jamie Mayer, 101 East Kennedy Boulevard, Suite 3700.
Okay.
I prepared everything except for that form itself. Our clients handwrote that form. So if those folio numbers or address are incorrect, everything that was prepared in the appeal package otherwise, those are the addresses. What was given to us in the denial, that is correct, where those are the folio numbers.
So I think if I'm to shorten what you just said, I'm to look at all the other folio numbers in the submittals, but not the application.
Do you mean, when you say the application, do you mean the original application that was submitted for the NCU, the request for an NCU determination, or the application that was submitted for the appeal?
This is called Appeals of Administrative Decisions.
Right.
And it asks the person who filled this out for the property information, for the property owner, for the applicant, and for the applicant's representative, of which your firm is listed as a representative. For the addresses, there's an address that does not appear to be associated with the property. And for the folios, there's a folio that appears not to be associated with the property.
Well, to my knowledge, the address should be 11345 South US Highway 41. That address, of course, there's some confusion in terms of what the property appraiser's record shows, because that is also an address associated with an adjacent parcel that the applicants do not own. But of course, that's independent. That confusion is independent of us. And there's two folios.
Hold on. So let's take that one up first. Understood, but it also lists 11537.
I'm not sure which address that is. That may be associated with the parcel that doesn't have street frontage. So the two parcels don't have frontage on US Highway 41. They're behind a series of other parcels that have frontage on US Highway 41. So, the addresses that the property appraiser might have assigned to it. That's why there is confusion with some of the ones on the street frontage, if that makes sense.
Well, so I understand how addresses can be confused,
Right.
but 537 doesn't appear to be anywhere near it. But let's put it aside for a second and go to what we know are more accurate in the property appraiser's map. The 51133 appears consistent with the write-ups, but 51139 is not. 51139.
I can't say that I have the folio numbers memorized. I'm sorry.
You want to look at it? Or Mr. Hisney, do you have anything to add to it?
No, sir.
Okay.
Sorry, we have a lot in this book.
And I recognize.
As I'm sure you can imagine.
Yeah.
So the property appraiser records cards that I have, I don't know if I can show, but these were in the original NCU application, which our firm was not responsible for submitting the initial NCU determination application. I think that was submitted last year. We're appealing the decision made on that. So the folios that I have are 51133.0200. That's the southerly one. And the other one is 51132.0000.
And that is in fact consistent with what your write-up has, but this application filed and signed says 51139.0000.
Well, as I said earlier, our clients filled that out by hand, but we prepared everything else. We weren't responsible for preparing the initial application. So
to be honest with you, I'm not looking for responsibility. I just want to know what the proper folios are. So if it's.
no, I understand. The proper folios are the ones that I just read. That's what I've been looking at on the maps. Those are the parcels that are at issue here, and those are consistent with the denial letter. So if that helps, yes, those are the two parcels that are at issue here.
Okay, and now, having said that, Mr. Hisney, since you were the evaluator of this NCU, does that pose any problem to you? Or can we correct the record here to indicate the folio numbers that are in the write-ups and appear also to be, I think, what you addressed in your report? So somehow you guys both knew this to be the case, but not the application. If that makes any sense, Tom.
Yes, I mean, our review was based on the two folio numbers that the applicant's attorney just stated. I would ask for Cameron Clark to give his opinion here as to whether the erroneous folio number on the application for the appeal poses any issues.
Well, this is Cameron Clark. It sounds like you're correcting it on the record right now. I think that's Mr. Scroll's intent. And the appellant's attorney has stated what the correct information is into the record. Mr. Hisney stated that there's no problem for him, I guess, going forward. If the appellant wanted to continue based on the need to correct the documentation, that's fine too, but it sounds like the issue has been identified and corrected in the record as of right now.
Thank you for that, Mr. Clark. So you've got two options. You can continue if you want. You can let me know that. If you don't, go ahead and reiterate read them into the record, the two folios that this NCU appeal has to relate to, and then we'll go on from there.
We'll take the option that you just stated.
Okay.
So the two folios at issue are folio 51133.0200 and folio 51132.0000.
Okay, gotcha. Thanks for that.
Thank you.
Okay. Now, would you also concur that these properties, the two folio numbers, are not contiguous?
That's correct. There's a kind of a thin piece of another parcel that separates them, so.
Mr. Hisney, that's consistent with your review?
Yes.
And with any hope that I don't get too involved and forget to ask this, I'm going to float it out there and you can address it at the end of the hearing. But we're going to talk about the due date, and with Hillsborough County, we're going to talk about the transcript production time, because as you know, the LDC calls for a 5-day review of the appeal. So I'm going to hold that to the end of the thing, and now give you the opportunity to present.
And Mr. Hearing Officer, if I can interject, it's my understanding from discussions last week that there
Procedurally, I believe
is
we had a request to show some
Go ahead, say that.
additional evidence.
Corbett, sorry,
Right.
again, for the record. Procedurally, we had a request for some additional evidence.
And Mr. Hearing Officer, I can refer you to the standard for that if you need me to.
Tammy Corbett.
Cameron, can you repeat that, please, for the room?
Yes, the Cami and I were both speaking to the same point, which is that there's an additional evidence request. The section of the code that would fall under Mr. Hearing Officer is 10.0501D4. The record on appeal is limited to the application submitted by the applicant to the administrator, and then the written decision of the administrator as it pertains to that application. The hearing officer can also use any applicable portions of the comp plan, the LDC, county ordinances, rules or resolutions, state and federal laws, rules, decisions. But it also states that if an order, if either the administrator or the appellant or intervener believes that in order to fully present their case, evidence other than that listed in 2 and 3 above must be presented to the hearing officer. The nature of the additional evidence must be disclosed to the other parties and the hearing officer not less than 5 days before the hearing. At the beginning of the hearing officer shall rule on whether such additional evidence may be presented. The hearing officer shall freely allow the presentation of additional evidence pursuant to this subsection where such is relevant to the issue on appeal. So as long as it meets the 5-day threshold, the hearing officer can consider whether or not to allow the evidence.
Okay, so am I to take it that there's an additional evidence proposal?
Jamie Mayer, there's just a few photos. There's some aerial photos that are, I think, considerably more clear than I took from Google Earth. A lot of the aerials that are in the record are old and they aren't visually as clear. I thought it would be helpful to have some context, an aerial from the property appraiser's website. So it's public record type photos, not adding anything, I don't think, substantive, but I think that it's just helpful for visual sake because this is a very visual issue.
Okay, so this was not submitted 5 days prior?
It was.
Oh, it was, okay.
Yes,
Is
sir.
there any objection?
No, sir.
Thank you. Okay,
Great.
thank you.
It'll be accepted.
Okay, thank you.
And then go ahead.
Thank you for bearing with us for all of that. I
No
appreciate it.
Yep.
So we're here today to appeal the denial of an NCU determination application. So the issue, the subject property is a junkyard. It was an existing junkyard and the appellants purchased it because it was an existing junkyard. They intended to continue that use. It's located behind an auto repair shop and a salvage yard and a boat salvage yard. There's some water. There's just a lot of junk in the area. And these two parcels, as you identified, are separated by that.
Excuse me, Mr. Hearing Officer, I see that the timer is not advancing.
Oh, thank you.
Thank you, Mr. Ismay. Go ahead and apologize.
Okay. In the denial, the county in large part relies on a lack of sales receipts, purchase receipts, and business advertisements, and on affidavits in opposition to support the position that the use is ceased. These affidavits in opposition, in fact, two of them acknowledge the fact that the junkyard is not a legal junkyard, which is actually true because from a zoning perspective, it's a non-conforming use, but it does not refute the fact that there is a junkyard. So it's unclear to us why the county relies so heavily on these opposition letters that don't really assert or contradict our position to say that an otherwise well-founded use has ceased. They don't show an evidence of cessation. And the county code itself and case law favor a finding of our non-conforming status. The county code's definition, which I'll show you on the next slide verbatim, but it contemplates storage or keeping of junk as a function of a junkyard in its definition of what a junkyard is. And case law affirms that storage of junk alone constitutes a junkyard use when analyzing codes very similar to ours, which contemplate storage as the function of a junkyard.
I'm sorry, that one sentence again. Case law or the definition itself? What were you referring to?
Well, so some other courts in other jurisdictions have analyzed codes similar to ours, which have definitions that include storage or keeping of junk, and they've come out that storage alone would constitute a junkyard use based on the definitions that contemplate storage as a junkyard use. So it's different from a junkyard that maybe makes active sales. People walk on and buy it there. Other junkyards simply are basically junk warehouses, if you will, like junk inventory, but the actual sales and purchases are elsewhere. So we have one of those kind of junkyards, but it falls within the definition.
Well, so that's good information to know, but the definition itself in the Land Development Code says or
Right.
storage.
Which means storage, keeping, here, I'll bring it up. Land used for the storage, keeping, handling, or display of junk, which means any of the above uses would be a junkyard.
So as far as you're concerned, storing the junk on the site makes it a junkyard.
Correct. Yes. And again, one of the cases that we reviewed, here's a quote from it, I'll just read it. Even if no activity or business occurred at the junkyard, storage of junk on the premises by itself constitutes a continuance of the non-conforming junkyard use. So this was a case in a different jurisdiction that analyzed a code that was similar in that it contemplated storage. It had kind of like that or construction. Also, there's no quantity threshold of junk to be a junkyard. So a few cars, a few boats is enough to be a junkyard. Junkyards inventory waxes and wanes with the sale and acquisition of junk. So, if there's a few cars on at one point and 300 another time, it isn't considered to be a cessation or an exceeding, the use that's allowed. So, and I'll show you the aerials later, these that were part of the record. The subject property has been since at least 1966 a junkyard and is still a junkyard. The appellants purchased it in 2016 and have continuously used it to store junk since then to that present day, which even in the light of code violations, which I will get into in a minute. So we find that the appellants have met their burden on the record to show nonconforming use. The evidence that is allowed to be shown or that is helpful to the determination are things like property assessor records, permits, aerial photographs, tax bills, other similar evidence. So there's no specific type of evidence prescribed, but these are the kinds of evidence that are allowed. Also affidavits from property owners themselves, adjoining owners, and other competent parties. So here the appellants submitted evidence. They submitted aerial photos, many affidavits, a business tax receipt showing that they are a junk dealer use on the property. They submitted a lease with a current junk dealer who's here today. He's been storing junk on the property. He's a licensed junk dealer, and he submitted an affidavit as well. And the appellant's own testimony as property owners, and they've been in the junk business their entire lives. So it's not clear to us what else the applicant would have to submit to show that there has been a junkyard use on the property from 2016 to 2018 and from 1966 to 2016.
Except that 1979 aerial.
Which the county did, the county says in their own, letter that was at one point in time. We don't know when that aerial was taken. It's hard to tell. To me, it looks like the whole area has junk on it, and these parcels, as I'll get into, have been used interchangeably by the people who own those storefronts and their predecessors and so forth. So I don't think it's compelling to say that, oh, just this one aerial in 54 years had maybe less junk, or it's hard to see if there was any junk. There could have been some tubes, some pipes, some sheets. It's hard to say. But because junkyard inventories wax and wane, and the nature of the business is you buy junk, when the price goes up for scrap, you sell it, and then you buy more, you start over again. With 54 years of aerials that showed junk pretty much always in the area, we don't find that compelling. Essentially what the county is doing here is asking the appellants to prove a negative. They're saying, well, the appellants have not shown that the use has not ceased at any point in time. The appellants have shown that the use has been continuous. So it's impossible for them to prove a negative. It's impossible for them to show something that shows that it did not cease. See, I'm confusing myself even trying to think of it. The county provides these affidavits in opposition as evidence towards the finding for denial. As I mentioned earlier, 2 out of 3 of them, including one of the ones from the prior owner of the seller, Franz Dubinsky, who himself stored junk on the property and is storing junk currently on the property, even though he is not supposed to be. They say that the junkyard is not legal. They said there was never a legal junkyard. That's correct. It's a non-conforming use. So these affidavits in opposition, in fact, are consistent with our position.
So trying to line this evidence up, those adversarial affidavits or competitive affidavits, whatever you want to call them, those were all in modern times.
Correct.
Do you remember, what was the earliest mention of a date in one of those affidavits?
I have, I'll screen forward a little bit. I have the pictures of them. Sorry, it's a little farther ahead here. Looks like 1997.
Right.
So I'll just go back.
But this conflicts with the aerial evidence.
Correct.
You agree with that?
Yes, because the aerials show junk since 1966.
The only aerial that doesn't show any junk, according to both parties, I think. Certainly, I wouldn't say Hillsborough County, but according to you, would be the 79 aerial.
It doesn't show like obvious junk in the photo, but again, I'm not really sure. It's hard to see. It's less.
Right.
But again, there's no quantity threshold. So I'm just going to go back. But yes. Another thing is that, the applicants or the appellants have a lease with a junk dealer who's a licensed junk dealer who's also been in the junk industry his entire life. And the county questions the lease's, value as evidence because it looks residential. I'll show you a picture of it. It's clearly a form lease that was originally a residential lease, but there's clear handwritten changes to say property and commercial. Clearly, the intent was a commercial lease, and we have an affidavit from the junk dealer saying, yes, I am leasing this property. My junk is on it.
This is Charles Crosby?
That is correct. The county argues, again, as I said, there's no quantity of junk threshold. They argue that the 2017 to 2020 aerials only show a limited quantity of junk on site. There is junk on site. There's cars, boats, scrap, pipes, and case law does hold the same. There's some cases that analyze, and I submitted these into the record, but there's some cases that analyze whether adding more junk exceeded what was allowed under non-conforming use statute. It did not. Or having only 2 boats, was that enough? Yes, it was, because there's no quantity threshold. The county, as I mentioned earlier, argued that we needed to show sales and purchase receipts and business advertisements. Not only were those not a requirement of the code, as you saw earlier, it was a suggested types of evidence, nothing required specifically, but also these kinds of evidence would not be available for the subject property because it's a warehouse, essentially. It's not a storefront. Nobody is coming up and buying things directly from that property. They wouldn't advertise it because who would advertise their off-site warehouse? The storefronts like Shoestrings, which is a parcel I'll show you on the aerial that is connected. It's actually the one with the long skinny strip that separates the two. They sell junk. They used to store their junk on the subject property, but they sold junk from their storefront. So there wouldn't be this kind of evidence. We couldn't produce it because we would never have sales receipts or purchase receipts or advertisements associated with these parcels.
To your knowledge, is there anything in the Land Development Code that references the terminology active junkyard?
No, the definition of junkyard simply says junkyard. Junkyard, colon, land used for storage, keeping, handling, or display of junk. Sorry.
So if I'm to take your previous argument of storage constitutes junkyard, then active junkyard, amongst other things, could also mean the storing of junk.
I would agree.
Well, that's your assertion.
No, that is correct. If you're storing junk, you're an active junkyard. Or if you're keeping junk, you're an active junkyard.
All right.
So.
Okay.
Again, one of the reasons that the county takes issue with the affidavits, the many affidavits that support the history, is that they mention doing business with Shoestring. As I mentioned earlier, Shoestring, with the appellant's express permission, continued to store its junk on the subject property. So in fact, those affidavits mentioning Shoestring support our position because it says that during this time, Shoestring was in operation. They were in operation, I believe, from their licenses from 2013 to 2018, 2018 being when Mr. Crosby picked up a lease with the subject property. But people who know the area very well submitted their affidavits, and they did business with Shoestring. They saw the parcels, they bought junk from those parcels, and Shoestring was using the parcels that belonged to the appellants to store their junk, and they used their storefront to sell it. So the appellants purchased it, as I mentioned, in 2016. It contained Shoestring's junk, and it also contained the seller's junk, and the appellants allowed both of them to keep their junk on the property. Shoestrings has since gone out of business, like I said, in 2018. And they were also dumping oil from their junk onto the property. So they had to clean those up, although the seller left his junk on the property and it's still there. Mr. Crosby moved his junk onto the property, and the appellants also have their own junk there. So it is a big mix of junk. I'll show you, here's the affidavit of Mr. Crosby. He's been in the junk business his entire life. He says he has knowledge of the property being a junkyard ever since he can remember. He uses the site to store and move equipment that he uses. So the junked equipment, you can see he is very involved in the business. So he stores his junk there. It's his offsite warehouse. This is the lease. As you can see, the word commercial is handwritten. It's not beautiful, but I think anybody could see that the intent was it's not about being a resident. The word house and resident are, struck through. And with the affidavit, I don't think it is intellectually honest to say that this is a residential lease. Here is just one of the many affidavits that are in the record, but a lot of them are handwritten, so you'd have to spend time looking at them. But this says from 2006 to 2018, Shoestring operated their salvage yard, correct? They stored their junk on the subject property. And this man says that to his knowledge, the site has always been a junkyard. These are people who have lived here, grown up in the area, and are involved in the business. And then this is a business tax receipt that shows that the property is used as a junk dealer. However, a business tax receipt itself, I mean, that's great evidence, but the aerials speak for themselves. So we would not even need to rely on that alone, but it's nice to have. Again, you saw these and how similar they are in their verbiage. We find that they're most likely form, and the seller has rallied this property owners against the appellants because there's bad blood between the seller and the appellants, which I will mention later. So here is the aerial. You see Shoestrings marked on there, and you can see that the appellant's parcels are directly behind Shoestrings and then up kind of into that little islandy thing that shoots upwards. So you can see why Shoestrings would use it to store their junk, because it's directly behind their property. They're the two parcels. So you can see exactly what we're dealing with here. And these are just photos from the right-of-way. You can't actually see the appellant's properties from the right-of-way because it's behind the storefronts. But as you can see, even the storefronts store junk on their properties. So this whole area is just, everyone's putting their junk everywhere. And I guess none of it is allowed under the zoning code, but here we are. I'm going to show you the aerials now. It became non-conforming in 1976, but also that was an old zoning code. So the current zoning code also disallows it. So it's very much, a non-conforming.
Just for a little history here, 76 was the year of the zoning code. Was that also the year of the placement of zoning?
I'm not sure.
Mr. Isnay, can you answer that?
The old zoning map?
Yeah, by our records, the definitive date we can determine is 1980. It may have been zoned prior to that, but the zoning atlases are back there are kind of inconclusive. So our review is based on zoning came in place in 1980.
Thank you, Tom.
So here are the aerials that I'm sure you've seen. I'll just go through them quickly. Yes, that's the 1971. It's hard to see.
Wait, hold on. You said 71.
Oh, I'm sorry, 1979 one. Sorry, it's the one from 1979.
Yep.
May I move forward?
There was a 66, wasn't there, or no?
Oh, yes.
Okay, so by the way, time is up, but I'm going to add 3 minutes to the clock.
Should I go forward?
Go ahead.
Okay. So I'll just go through these. As you can see, there's Shoestring here, 2014 is when Shoestring was already operating. And here it is today. Pretty junky, I guess.
Go back to 66.
Okay.
You think that is in 72?
What do I think it is?
Mhm.
It looks about the same. It's a little stretched out, but I can see there's a bunch of like objects in the middle there. If I had it on the Elmo, it could point, but
Okay, go on a little further. Goes right to 79. And that, in that 79 picture, you see the structure of the storefront up front?
yes, I think that would be the bullfrog thing today. Or it might be shoestring.
Okay, then if you go to the west, there's a structure, there's a something.
Mhm.
Is that a boat or something like that?
Maybe a semi.
You think that's on the subject property or no?
Gosh, let's see it. Looks like the folios are marked there, but they change in size, so it's not exact. I can't make that determination.
But it's close.
And that being said, as I mentioned earlier, one snapshot, I mean, you can see the whole area has got junk everywhere. We don't know when this was taken, but I think that everyone is in agreement. I think even the county might, of course, I can't speak for the county, but at least from 1966 until 2016, it seems that there is no question as to the fact that it's been a junkyard. The question is, did the appellants use it as a junkyard? And of course, our answer is a resounding yes, and we have the evidence. So I think my understanding is that that's the time period that's really in question, just because it's new and it's when it belonged to the appellants. And so that, we've provided the aerials, but we think that it's pretty clear from the affidavits and the aerials that it's been a junkyard for a very long time. And our use of it, or our appellant's use of it, is in question, and that's what have shown and have brought affidavits for and so forth.
Go ahead and take it up to around what's the closest one to 2016?
2020.
2008. The back one?
Okay.
2017.
So this shoestrings would have been still using it at this time as well as the appellants and Mr. Zidvinsky.
The cars that are parked, do those appear to you to be on the subject property?
Yes.
They go on to the 2018. Would you say the same thing about that?
Yes.
And then for the folio that's to the north of that, do you think are there some
I think there's, I can't, I'm
things
kind of having a hard time seeing through this glass, but there's a bit of a glare. But it looks junky to me. It also looks like it's gotten a lot more overgrown than it was in the 70s.
All right. Anything else?
Well, it sounds like my time is up, but if I can just.
You have a quick closing, you're welcome.
Yes, please. Thank you. So the reason that there are code violations on the property is because the seller who stored junk on the property and is still storing junk on the property reported the appellants for code enforcement violations because he owes them money. They're in litigation. It's ugly. There's bad blood. But the code enforcement cases themselves cite junk, inoperable vehicles, accumulations, and outside open storage. That's why the appellants had to submit for the nonconforming use official determination, because they can't rectify the code enforcement violations without losing their NCU status, because that would require them to remove junk. They've even left the junk. They're letting the fines run. The fines have been running for several years now. They're still collecting junk there because they know that if they rectify the violations without the NCU determination, then they will lose their status. So once they get, if they can get the NCU determination, the code violations will go away and they can continue to operate as a junkyard as they have done and has been done on the subject property for 54 years. Thank you.
All right, thank you. And did you bring Mr. Crosby with you? Is that who's here? Okay, can I have a question with Mr. Crosby, please?
Yes.
Morning, sir. How are you?
Morning, Charles Crosby, 3500 Dover Street.
Mr. Crosby, how long have you lived in the Gibsonton area?
Since 82.
82. Yeah, I believe your affidavit said as long as you can remember, which I don't know how long that is. It's always been used as a junkyard. What are you remembering back to?
I remember back in the 70s buying cars and stuff in that area and seeing the junk there. And I also knew Mr. Shoestring, and also when he lost his child and everything, that's the reason the business actually started going downhill.
That's all I needed to hear. Thank you, sir.
Okay.
All right. Sir, yeah, if you wouldn't mind. All right, with that, we're going to conclude the appellant's portion of this, and Tom, I'm going to turn it over to you for the county's portion.
All right, well, the property that we're dealing with is currently zoned RSC 2, CN, and CG. It is, the applicant requested a determination of nonconformity for a junkyard. A junkyard is not a permitted use of any of the current zonings of the property. In review of the materials that were submitted, there's photographic evidence and some other evidence submitted that this junkyard was on the property by 1966, if not perhaps earlier, according to some affidavits. Prior to 1980, this property was unzoned, and therefore a junkyard was a permitted use. By 1980, this property was zoned RSFD, C1, and C2, and none of those zonings permitted a junkyard. So at that point in time, in 1980, a junkyard was no longer a permitted use of the property, and therefore the junkyard is a non-conforming use of the property. Direct your attention to section 110301E of the Land Development Code, which deals with non-conforming use reviews, and it talks about the basis for decision. It says the determination of the administrator shall be based on clear, substantial, and convincing evidence regarding the nature, extent, and date of establishment of the nonconformity. Such evidence may include, but is not limited to, deeds, property assessor records, permits, plan approvals, utility bills, aerial photographs, tax bills, vested rights determinations, and other similar evidence. In the absence of such evidence, the administrator may, at his discretion, rely upon affidavits from a property owner, adjoining property owners, and other competent parties as the basis of determination. So in doing our reviews, and in non-conforming use reviews in general, we take into account all the evidence that is submitted by the applicant, also any evidence that our staff can find, and we view it in totality. Very rarely, I would say, in non-conforming use reviews is there a specific piece of evidence that is a golden bullet, so to speak, that definitively proves the case one way or the other. Sometimes there is. Most often, though, it's an aggregate of evidence that is being taken into consideration by the staff. But again, the code talks about clear, substantial, and convincing evidence. Now, and let me state that although staff, we perform our review and look for evidence ourselves, the burden of establishing the case is always upon the applicant, not upon staff. So the junkyard is a non-conforming use that's not permitted by the zoning. It is the burden of the applicant to present clear, substantial, and convincing evidence that it should be certified as a legal non-conforming use. Now, with regards to the nature of the use, the applicant has pointed out that the definition of junkyard is land used for the storage, keeping, handling, or display of junk. Well, that is correct. However, when we're dealing with non-conforming uses, even ones that had been certified already as a legal non-conforming use, the structure of the code is such that uses that are certified as legal non-conforming are allowed to remain in place and continue to operate, subject to some restrictions. However, if the use ceases for 90 consecutive days or a total of 180 calendar days in a one-year period, then the use is extinguished. So as part of our review and part of the burden on the applicants is to establish continuity of use. Well, continuity of use means there's not a cessation of use. And the code specifically defines cessation of use in a very critical manner. And that is, For purposes of this regulation, meaning non-conforming use reviews, cessation of use shall be defined as the absence of the principal activity or function comprising that use, irrespective of the presence of dormant buildings, equipment, and/or materials associated with that use. So that means that in and of itself, simply the presence of junk on a piece of property where there's not an active business activity does not constitute continuation of use. Another example would be a piece of property that is fully developed with a restaurant, and that restaurant is not a permitted use of the property. If that restaurant goes out of business for more than 90 days, that non-conforming use, if it were established to be legal to begin with, or even if it hadn't been, any opportunity for legal non-conforming use entitlement is extinguished. Just irregardless of the fact that the site is completely equipped and built out for a restaurant, because and this language inserted in the code some years ago, because again, the overall structure of the non-conforming use regulations is that these things, if legal, are allowed to continue, but ultimately the county wants them to go away because they're non-conforming uses. Well, if simply having a building, or in this case, junk on a piece of property without an active business activity is entirely contrary to that notion. I mean, you could have a vacant restaurant on a piece of property for 20 years that sat there without any operation whatsoever for 20 years and still maintain its legal non-conforming use status. Well, that's completely contrary to the intent of the regulations, and that's why
Let me ask you
the cessation of use specifies that.
This is a very interesting point on your part.
Mhm.
So I need to ask the question, because you can imagine over the years, I've heard lots about junkyards in Hillsborough County, but so you go to the non-conforming section and it talks about, hey, the presence of materials, in this case, I think is the extrapolation that is being made, doesn't necessarily constitute that use.
Right.
But the definition in the code for junkyard necessarily points to the fact that the storage alone can constitute junkyard. So those things seem to conflict a bit.
Yeah. Well, you need to take the code into account in its entirety. And again, I can tell you that this language in the code dealing with cessation of use, which went in there some years ago, was put in there specifically to address situations like that. Because at the time, if you looked at the definition of use, it's still in the code today, it talked about what a property is arranged for. And there was an applicant and a non-conforming use review. And our argument was, well, the use is there because the buildings are there, the use is arranged for that. There was a zoning interpretation done on that point. And the interpretation was exactly what I said, is that, yes, okay, that's what the code says, that's what the definition is. However, that's contrary to the entire intent of the regulations for the cessation, non-conforming use and cessation of use.
What's the code site of that? Well, I got you there.
I'm sorry?
What's the code site?
Yeah, it is 110306C. And anyway, that interpretation was appealed and we prevailed on the interpretation. And the code was then subsequently amended. This is some years ago specifically to address that.
I don't think that's been made part of the record, has it, that you know of?
What do you mean?
That interpretation?
No, I'm just explaining the background of this regulation, but you can just read this regulation in and of itself. And absent even the background, the code says in Article 1 of the code, and I can find the site if you want, is when two provisions of the code talk about the same thing, but perhaps aren't in strict agreement, then the one that, the provision that imposes the greater regulation or the greater requirement prevails. So, but again, the clear language here about cessation of use means that, simply dormant equipment, materials, or buildings sitting on a site does not in itself obviate cessation of use. So, and that's important for this review. Okay. So when we look at this, and then let's talk about aerial photos real quickly. Aerial photos are a snapshot in time. In and of themselves, they show only what was occurring the day the photo was taken. Whether the property is vacant or whether it has a junkyard, it only shows what occurred on the day. Certainly, they're an important part of reviews, but in and of themselves, again, it's just part of the total evidence that is utilized in the review. So in this case, yes, there's aerial photos, there's affidavits, some positive, some contrary to, the presence of a junkyard here. But one of the things that we had asked of the applicant to submit during this review was evidence of active business activity on the junkyard, right? Such as lease payments or sales receipts or purchase receipts, things like that. Now, when I looked through the materials that were submitted as part of the review, the affidavit submitted by the owner and others appeared that the junkyard was the operation, right? I see now in the appeal, there are some statements in here that this property functions as a warehouse for a junkyard operation that apparently operates off-site. So that's new.
It's new information as far as you're concerned.
Yes. I didn't see in the old record that it was characterized as a junkyard, a warehouse junkyard for an operation that occurs off-site. Perhaps I don't see that, but I don't see it. In any case, but as for the claim that this, both at the time of the review and now, again, we specifically asked, do you have evidence that, can you submit sales receipts, things like that, to show that this is an actual active business operation rather than a defunct junkyard. And we focused on the time frame that the property owner purchased the property. We haven't ignored other parts, other years, but it does stretch very far back. And none of that was forthcoming. I see now, even with the additional materials that were submitted in the appeal, or rather the appeal statement, I still don't see any things like, lease payments, sales receipts, purchase receipts, whether this is functioning as a warehouse for some offsite junkyard or offsite business activity. We still don't see that any of that evidence has been submitted.
Let me make sure I understand. So despite the fact that they believe that this was the storage location only, is it your point that, well, if there was a junk business, then you still would have had receipts, even if it was offsite, related to the offsite portion?
Correct.
Because they seem to indicate that they weren't talking about the offsite location, just the
Well, we're
offsite.
talking about this, but again, it needs to be in connection with it. And again, that's new evidence. I mean, or a new perspective on the application. Our review was based on the representation in the application that to my knowledge, there was no reference of some offsite location. This is functioning simply as a warehouse.
One more question.
Yes, sir.
When you got the original NCU request, did it come directly from the applicant, or was the law firm involved?
This law firm was not involved. They initially had professional representation by a planner, who then, partway through the process, exited the picture. And then, to my knowledge, certainly this law firm was not involved in the review,
right?
Only in the appeal. So again, when we look at the evidence in total, and particularly, and I think what is absolutely key here is the fact that that there has to be, that the presence of dormant buildings, equipment, or materials associated with that use does not obviate cessation of use. Right? And that if there were indeed, and of course, you can read our findings and everything else. And like, for instance, they mentioned the lease. Well, if you read the lease, it does make reference to commercial activity, doesn't say a junkyard. Then you read through the body of the lease, and it talks about residential use. In fact, actually limits the property to a residential use. Besides, so again, we certainly take very, very seriously these reviews, and certainly are very respectful of property entitlements and investments. So we take it very, very seriously. But at the same time, we are required to see that there is clear, substantial, and convincing evidence. And in this view, the totality evidence we find does not sustain the claim that there has been a continual use of the junkyard on this property from when 1980, but most particularly in the last years since the purchase of the property owner, when those kind of records should be readily available to the applicant.
Okay, thank you, Tom. I think I have a pretty decent picture now painted by both parties. Do you think that there is enough nuance to the presentation now that it would have been worth looking at in the original NCU?
Well, certainly the narrative and everything that's been provided now, I think, provides a much clearer picture about the transition of use from, let's say, when it was utilized by shoestrings to now. But I find that still what is missing are the type of records that we had asked for during the review, which to demonstrate, active business activities such as sales receipts, purchase receipts, payments on the lease, those sort of records. I don't see that there have been any of those records have been submitted.
Even if that was occurring on another site?
I'm sorry?
Even if those activities were occurring?
Well, again, the representation that this is a quote unquote warehouse junkyard for offsite activities, a new representation. I don't see that in the past record. When I read, like for instance, the item here, it's Exhibit A from Mr. Cropperty. He says, I've been operating a junkyard facility on the above cases. He cites the code enforcement cases, which are for this property. So it means this property. Since they purchased it in 2018, I buy and sell cars, trucks, et cetera, but I don't see anything. Certainly the representation here is the activities occurring on the site. That it's not like a warehouse or some offsite. And if that had been the case, then they needed to bring that to our attention, but I don't see that was the case when I read the information that was submitted prior.
Thanks, Tom. All right, the applicant has an opportunity for rebuttal.
Thank you. Hi.
Go ahead and say your name.
Jamie Mayer, sorry.
That's all right.
We have met the burden. I read the burden to you. I put it on the PowerPoint. I understand that the code must be read as a whole, but that was the burden of an NCU determination application. The burden is not to show that there was never a cessation. The county hasn't shown that there was a cessation. The county hasn't shown that there was 90 days when there wasn't junk stored on the property. We've shown that there has been junk stored on the property, certainly the entire time that the appellants have owned it, and certainly in the past. So storage, as I said earlier, storage is the junkyard operation. That is an active junkyard use per the land development code. So saying that we've been operating a junkyard, yes, we are, and it is currently operating as we speak because there's junk on it. The inventory waxes and wanes. As I said, we didn't assert that it's a warehouse, therefore it's different than a junkyard. It's a junkyard. The analogy is that it's a warehouse where the junk dealers store their junk. Some junkyards will be operated differently, but ours is operated actively as a place to store junk per code. The county doesn't get to decide what constitutes records of an active use when those kinds of records wouldn't be associated with our property, and we can't change that. We can't change the fact that we wouldn't have sales and purchase receipts or business advertisements for the folios at issue because it's used to store junk. There wouldn't be advertisements. There wouldn't be sales and purchase records. We are not concerned with property that is off-site. We're concerned with the property at issue here, and the county has asked us for things that we simply cannot produce. But we have produced evidence to the kind that is contemplated by the code. We've shown that there was a continuous use. We've met our burden. Thank you.
Can you show me where the burden is in your? Need to be able to make fast reference to it in the manual, the exhibit binder.
Yes. All right, it'll be tab 6.
Tab 6.
And then I'm sorry, I'm like Reading under pressure sometimes makes you unable to read. Well, I cited it in the PowerPoint. Here,
Take your time.
11.03.01E, so it is under that tab.
Basis for decision.
Yes.
Give me 1 second. While I'm perusing this, you might want to give a little bit of thought to, I'm going to ask you where the administrator erred. Because that is ultimately the conclusion that would need to be made to overturn the decision by the administrator. So give that some thought for a second. While the applicant gives that some thought, under this that I'm being referred to, I think, did you find it anywhere yet? It's 110301.
Are we talking about the code?
Yeah.
Oh, I'm sorry.
E, 110301E.
Oh, I think it's the part I cited, correct?
Yeah, you did cite it
okay.
at one point.
Yeah, I have that. Okay, yes, sir.
And I really am, I don't have a destination in mind, but I want to research it with you. The determination of the administrator shall be based on clear, substantial, convincing evidence, which you mentioned, regarding the nature, extent, and date of establishment of the nonconformity. It seems to lean on that date of establishment.
Well, that's only part of the review. Certainly, as with any nonconformity, if that nonconformity, whether it's certified as illegal or is not yet certified but under review, the opportunity, if there has been a cessation of use, then even the opportunity for legal nonconforming use status has been extinguished. For instance, someone could show that, yeah, we operated whatever use for 5 years. It's been closed for 5 years, and now we want to restart the use. Well, there's been a cessation of use, and they come in for the nonconforming use review at that time. Well, there's no opportunity for that because it's been extinguished.
So what do you believe the time period was that extinguished the use?
I'm sorry?
What do you believe the time period was that extinguished the use?
Certainly, again, it's up to the applicant to submit clear, substantial, and convincing evidence of an actual business activity on the site, because you got to link it to the definition of cessation of use. And we saw none of that type of evidence was submitted by the applicant, particularly concerning the amount of time that when he has owned the property. We recognize that somebody trying to go back 20 years in time to an operation that he didn't own and nothing to do with, that business, whoever ran it at the time, could be very, very difficult. And that's why the code talks about evidence of various types, including affidavits. However, the closer you get to current time, right, then certainly those kind of materials should be available to the applicant to provide that clear and substantial evidence. Affidavits, again, if you read the language that we were referring to, is really to be used in the absence of such evidence, right? Then the administrator may rely upon affidavits. So yes, there's been affidavits, but they really come into play more so when in the absence of other evidence, and the other evidence dealing with the time frame, at least, that this applicant has owned the property should be readily available.
Thank you.
And that's the type of evidence that's first referenced by the code here. The reference that is clear, substantial, and convincing evidence of the nature that lists all this other stuff, right? Types of things that we had asked for. Going to affidavits is, again, in the absence of such evidence that we may rely on affidavits.
All right, go ahead.
Just to answer, I'm just going to answer your question where the administrators erred, correct?
Yes.
The administrators erred in applying and adding a requirement that we show a lack of cessation of use to what we are required to show in terms of the clear and substantial or convincing evidence. The cessation of use code is a different part and it's not part of our burden. So that it's an error to apply that to our burden. It doesn't make sense. And also the administrators erred in saying that storage does not constitute an active junkyard use when it is a junkyard as defined by the county code. And the appellant themselves would like to speak for a moment if that is okay.
It is. Good morning.
Good afternoon.
Okay, is it that time? Yeah.
My name is Paul Savage. My address is 12632 South US Highway 41, Gibsonton. I've lived in the area since the late 50s. I've been in the junk business since 1970, various types of it. We bought this parcel property. Knowing that it was a junkyard, the county record showed that it was a junkyard. We got a permit for a junkyard. We had some people that were on the site to begin with, Shoestring Motors, and they were encroaching on the whole property, and they had approximately 300 cars there. And we had an environmental study done. Because it was a junkyard, we wanted to make sure we weren't buying something. And we found out that through Sawgrass that did the environmental, that these people were dumping transmission fluid and oil down the septic tank. And where it was leaching to, we didn't know, and they didn't want to do a phase one, so we asked Shoestring. We already had some of our stuff on the far end and some cars there. We asked Shoestring to remove his cars from our property because of bad housekeeping. He called a crusher, had a crusher come in, and they crushed 300 cars plus. So they moved the cars. We says, we'll give you the time to go ahead and do it. You just go ahead. We'll put our stuff on the side and as you get stuff out. So they moved their stuff out. We continue to put our stuff in, and I have different locations. And I bring stuff in depending on the size and the amount. It's just like there's probably 20 loads of pipe that came off of a farm in Winter Haven that the hurricane blew down.
You're gonna have to do this quick. I gave you an opportunity, so.
I'll wind it up real quick. So anyway, we have continually used this. I'm in and out of there. Charlie's in and out of there. We were well aware of the 180 days, and Steve Allison told us this, and we were going to move everything off of it, and he said, don't, because you have your application in, just continue to use it, but kind of low key it. And that's all I have to say.
All right.
Thank you.
Good enough? All right, if nothing else from the appellant, I'm going to go ahead. Anything else from the appellant? All good? All right, with that, we're going to, two issues. We're going to take up two issues. One is the due date, and let's talk about the transcript. A little bit of a complicated record here. Now, you're right by the code to have it in 5 days. I'm going to tell you that based on what's going on with trying to get transcripts right now in the pandemic and so forth, this probably warrants a little bit more time. I'll throw out the usual 15 working days, but by all means, I'd like to hear from you.
Tammy Corbett for the appellant. That would be acceptable. We'd like you to have enough time to consider all the evidence. There's a lot.
Thank you for that. All right, and the next issue is, who can speak to the transcript delivery? Is there anybody here that can speak to that? Carmen?
I can, I'm virtual.
Carmen, go ahead. Once you do it, say your name and say what Hillsborough County.
Carmen Mason, Hillsborough County Development Services. The transcript since COVID started and we're having these hearings has continually been late. We're supposed to get it within 5 days, but that has not been the case. And usually we have to ask for it.
Okay. Well, the applicant has been good enough to say, okay, we'll take 15 working days. Carmen, if you wouldn't mind just letting the clerk know this is an appeal, and so it would normally be a faster. Normally, I'd have to turn in a decision in 5 working days. We got a little bit more time this time, but if we can have the transcript in 5 working days, it'd be great.
Yes, I will email them when I get back and ask them, let them know that we're supposed to have it in 5 days. We need it as soon as possible.
Thank you, Carmen.
You're welcome.
All right. With that, we're going to go ahead and close Appeal 2011-51, and that'll do it for our hearing today. Thanks, everybody.